Congratulations to the teams that have made it so far. We have IE Law School, Sciences Po, Paris Saclay, and Complutense. So excited to see how things go. Before I introduce our first speaker, just wanted to clarify a bit about how today is going to run. We're going to have our opening speeches, and then our friends in session 2 will be taken to conference rooms. We'll proceed with Paris Saclay versus Complutense, and then we'll have a break, and then we'll bring down IE and Sciences Po. Complutense and Paris, you both are allowed to watch the second session if you wish, because you have already presented. Whoops. And the rest of my speech I'll do at the end. So I'd like to introduce Martine from ELSA France to the podium. Thank you.
Thank you so much, Dane, for inviting us here. On behalf of all of ELSA France, I would like to thank you for the invitation. The first session in Paris was incredible. It was really nice to have you there. I would like to, of course, thank Perez Yorca for welcoming us here in this beautiful place. Thank you to our juries for coming. And yeah, good luck to the teams. Have fun.
Hi everyone. For those of you who don't know me, unlike other years, this year I'm representing ELSA Spain as its Secretary General. And we just want to say that we're very proud of ELSA IE from ELSA Spain on the big growth and influence it has had on the whole network, putting a high standard of motivation and dedication for everything we do. And obviously to the IE Law School for always being supportive of ELSA's work, and to Perez Yorca as well as a great partner. So thank you very much, and I'm sure this is going to be a great competition.
I would like to welcome all of you to this Moot competition, and in particular to those of you who come from abroad. It's really a pleasure to have you here. And I'd like to start to thank the members of the jury today for taking the time. All of these are extremely busy people who devote their time to training the future leaders and lawyers of the world. So I hope this is a valuable investment of your time. And I would like to say that when over the past few months, when I meet with law firms, companies, or institutions from public administration, and I ask them, in this time when artificial intelligence and digitalization are changing the way every professional, and in particular the way many lawyers work and the provision of legal services is changing, what is it that they mostly value when they recruit young lawyers or professionals for their law firms or institutions? And they all come to same, it is critical thinking and judgment. These will remain as the most relevant skills that you will be tested on and that you will have to prove when you start your careers. And this is precisely the kind of exercise, the kind of activity where you have to work on your judgment and on your critical thinking. So congratulations for having made it all the way here. I hope that you enjoyed, that you also have that you get valuable learning from this, and make sure that you not only profit, but whenever you are applying to scholarships, to programs, to internships, do say that you were part of this activity, because this confirms that you have worked on your critical thinking and on your judgment skills. And last, special thank you to Dane and to the ELSA students for investing your time and your energy in creating this very valuable community. So I hope you enjoy the competition and let the best win team. Maybe IE, maybe not. Good luck to all.
Hi, everybody. So I just want to say I'm very proud of every single person in this room. As VP of Academics right now, it's been truly remarkable to see the experience that everybody has gone through and the growth that you have all accomplished. And as Dane said, as newly elected president of ELSA IE, it is truly an honor to have such a legacy to live up to. And I hope to continue this mock trial and to make sure that it is everlasting. And I hope that the best team wins tonight. So, good luck!
And I'd like to close everything out by doing what I always do when we have our competition, which is to tell the story of why it is called the Mitchell L. McLean Trial Competition. Obviously, it's a named competition. There's a reason behind that name, and it's quite personal to me. So I'm very glad that we're able to continue that legacy. So here's the story. In 2013, I was 10 years old, and my birthday wish was actually to shadow a judge. I was a weird kid, and I actually got that wish. I was able to shadow Judge McLean, Mitch McLean, actually for an entire week, and he ended up becoming a very close friend of our family, and we spent a lot of time with him. About a year later, Mitch McLean drowned in Sunset Beach on the Outer Banks of North Carolina, attempting to rescue somebody from drowning themselves. He actually did rescue the person, but he unfortunately passed away. And obviously that was pretty devastating. But on top of all of his paperwork that he was working on at the time, there was this letter that he had written to me that he had never sent. And it basically was a testament to continuing my legal journey and becoming a judge. And so I've taken that to heart, quite literally. And here we are. I'm so fortunate to be able to name the competition after him and, continue his legacy. But he was a great judge, and hopefully I am also going to be a good judge today. We'll see. But yeah, it's a really important piece of my life story, and I think it's really fitting to be here with students whom he always loved to, welcome, and it really shows kind of what the law is, which is this unwavering dedication to defending others. So, thank you so much for being a part of this, and I'm really excited to see the arguments. Obviously, this case is based on a case that may arise in the near future, and it's a case that these arguments will probably be repeated in actual open court in a few months' time. So highly recommend, paying attention and, really understanding kind of the depth of this, because this is a genuinely, this is one of the very few things that has never been resolved before in a U.S. court. So we're about to resolve it right now. Super exciting. With that being said, we're going to take, what time is it right now exactly? 3:18. We're going to take a quick 7-minute break to escort the teams up, and then we'll begin promptly at 3:25. Okay? All right. Petitioner, are you ready to proceed? Okay. Respondent, ready to proceed? Okay. We are calling case 11-1323A, United States, appealing from the Circuit Court. We will hear oral argument from the petitioner.
Okay. May it please the Honorable Justices of the Supreme Court. Kennedy Jefferson was elected president in 2016. After his first term, he stood in for a second term, but lost to his opponent. In the weeks leading to the inauguration of the new president, Jefferson published on the POTUS Twitter account a video encouraging his supporters to take back the country, thus leading to a wave of chaos throughout the country. This call led to the Capitol insurrection, resulting in him being convicted in 2020 under 18 U.S. Code 2385 for advocating the reversal of government during this campaign for the 2024 election when he was elected president. Today, we confront a matter of profound significance that strikes at the very heart of our democracy. Whether a conviction on account of advocating the overthrow of the government under 18 U.S. Code 2385 disqualifies an individual from holding the office of president under Section 3 of the 14th Amendment. These questions implicates not only the integrity of our electoral process, but also the sanctity of our democratic institutions. At the outset, it is crucial to acknowledge the foundational principle upon which our nation was built. The Constitution of the United States serves as the bedrock of our democracy. outlining the powers and responsibility of each branch of government. Yet, as we delve into the history of the US, we encounter differing interpretations regarding the nature of presidency. As we established in the brief submitted to this esteemed court, the weight of historical evidence, legal precedent, and constitutional interpretation indisputably support the assertion that the President of the United States holds an office. To suggest otherwise would be to disregard centuries of jurisprudence and undermining the very foundation of our democracy.
Counsel, I'm going to interrupt you. The Constitution says engaged in insurrection is what prevents you from serving office. How is the speech published on a Twitter account considering engagement in insurrection?
Well, we based our brief on what Attorney General Stanbury said in part. He, in the mid-1860s, he interpreted the 14th Amendment, advocating for a common sense approach, and his assertions that individuals who incite rebellion through speech or writing fall within the scope of the disqualifications clause is what we used. And since Jefferson did a speech on Twitter, it is our understanding that it falls under this the disqualification clause. Okay.
May I ask a question? Hi. Can a mentally ill person become president of the United States?
Well, we believe.
You know, this is it's not exactly the subject matter of this case. However, it's a question. Can a convicted child abuser become a president of the United States? I think they're both matters that our founding fathers would never have expected to be. Okay.
Yes.
However, the Constitution does not keep silence on that. It only lists 3 requirements: be natural born, residency of 14 years, and 35 years old. And so I asked myself, the Constitution was drafted and was the architecture of the Constitution is the sharp differentiation of the 3 powers, but also checks and balances. There are many checks and balances. And I wonder if the founding fathers did not set up a specific check and balance or a specific provision, isn't it the electorate, the judgment of the American people, the ultimate balance, check and balance for this situation?
It's actually my co-counsel that's going to be talking about that, so I'm just going to try to answer your question.
Okay.
But he will talk about it.
Take your time.
In the US, there are the how do you say it in English? The electoral body. It's not the people that vote.
You're referring to the college.
Yeah, thank you. It's the college that votes. So people can vote for the college, but then the college votes for whoever they want, basically. So maybe, yeah.
But I think what my colleague judge here is saying is if there is only 3, the Constitution and the president obviously has a huge role in the United States government, and if the Constitution really only has 3 requirements, which are the age and the citizenship status, why would we as a court be limiting the ability for somebody to run for president? Would that not be overstepping our boundary according to the Constitution? I mean, the Constitution is very, very clear in that it is not clear. It is extremely open to allow any natural-born citizen of the United States to become the president, the leader of the people. So, tell me.
This is why we are talking about the 14th Amendment, because it's not about if he can be president, it's about if his actions that he has taken pose a threat to the Constitution and to the rule of law in the United States.
I want to hear a little bit. It says ineligible for employment by the United States or any department or agency thereof. There's another question as to whether or not being president means that you're serving as an employee of the United States. I would say that you are serving as the president, and I don't even know if I would consider the office of the president as a department or agency.
In the, you're referring of the Section 3 of the 14th Amendment?
Correct.
Yes. In this provision, it also states that people having previously taken an oath and the president takes an oath, it's in the Article 2, Section 8 of the Constitution. He takes an oath to the best of his ability, preserve, protect, and defend the Constitution of the United States. So it was our understanding that since he takes an oath, then he falls under the scope of the 14th Amendment, Section 3.
Thank you, Counsel.
Counsel, thank you. Following up on that, Section 3 of this amendment does not exactly mention the president or the vice president as two of the potential officers that could whose engagement in insurrection or rebellion might lead to disqualification. In other words, they refer to electors in particular, and there is a limited list of those agents, if you want, senator, representative, elector of president and vice president, or alternatively, but in a subsidiary manner. In other words, they identify some positions, some roles in the constitutional architecture of the United States, such as those actual members of the legislative power, those electing the chief or the leaders of the executive power, but not themselves. Do you see any difference in that, or how should we interpret it? How do you think we should interpret this?
Well,
should we try to amend the amendment of the Constitution? Should we just expand the interpretation of the text?
Well, actually, in the Section 3, they also refer to an office, and we argued that the president does hold an office, which means that he will be also subjected to Section 3. I don't know if it was your question.
And what does that actually entail? To have an office, to hold an office? How can we assess whether or not somebody holds an office under your definition?
Well, we looked into historical position of the House of Representatives, in which they talked about the emoluments clause, foreign emolument clause, of the Constitution, and this clause is the president is subject to this clause, which is one of a justification of why the president falls under the holds an office and therefore falls under the Section 3. And we also had a we also looked into Latin's doctrines. And since most provisions were taken at the same time after Reconstruction, after the Civil War, they should be interpreted under the related status canon, which further justify why our position.
Go ahead and proceed.
Okay.
Oh, that's what I was going to ask. So if this court is to disqualify Mr. Jefferson from becoming president, does that not set a precedent in that almost all speech against the United States becomes engaging in insurrection or rebellion? Will we now be able to disqualify people for criticizing the government, or perhaps saying something that slightly leads to a riot or protest?
We believe that it's more about the fact that the president must be he must be held accountable for
Sure.
his actions and less about what people could do. He was in a position of power, so this was also an issue. And because he used a POTUS official account, which is the President of the United States account on Twitter, more people, not only in the United States but also outside of the United States, were able to see this video.
Counsel, sorry, I just wanted to go back a little bit to the nature of the oath that the president actually, the allegiance to that oath.
Mhm.
And I was wondering what kind of nature or what kind of consequence does it have to actually plead allegiance to that oath? In other words, how can we get some sort of material content of that allegiance? Is that just merely aspirational? Does it just show a little bit the axiological realm in which we are just expecting a president of the United States to behave? Or does it mean that once an elected president engages into that oath, it is up to them to determine what it means to faithfully discharge the duties of the office on which that person is about to enter?
We think that this oath.
Let me
Yeah.
just put it into a yes or no, which is if I take this oath as President of the United States and then I violate the oath, can I be held criminally responsible?
Can I answer not in a yes or no?
Sure.
Like explaining?
Yeah, absolutely.
Yeah. The first thing that is going to be that's going to happen is obviously the impeachment procedure. But since the
Okay, but let me interrupt you. So you just mentioned that the way that we would deal with this is through the impeachment procedure. That's through the people. So why would the court be getting involved in any regard in this specific case? I mean, if we are saying, oh, well, if I violate the oath of office, which is another thing set forth, then why is the Supreme Court getting involved? Why can we not just leave it up to Congress, which they did try to impeach him? I think it ultimately failed. But if that is how it is, if the will of the people is to keep him in office, who are we to remove him?
Well, the defendant was convicted under 18 U.S. Code 2385, so it's really comes from that. If the defendant wasn't convicted, then we wouldn't be here. So that means that there is a question to be asked about this particular case, and it is our belief that people need to be held accountable for what they do, for their action, especially people in power, because if we just let everybody do whatever they want, then what of the rule of law, what of the democracy, what of everything that makes our nation?
Counsel, why do you think we need judicial accountability instead of merely political accountability in this case?
To set a precedent, to set into stone that it shouldn't happen again, and that if especially a president, but any person holding an office, haven't taken an oath, is to do something like that, take part in a rebellion or in an insurrection, there will be consequences. So yeah. How much time passed?
You have 10 minutes left of your original time.
Of my 30 minutes?
Of your, well, now 25, yes.
Okay, thank you.
I have a question. You were talking about the judicial power, but actually the power of the people was invested in the Constitution, and then it was ratified in the elections. So why judges should actually have more power than people in a democratic country?
I just didn't hear the end of the question. Sorry.
The power was invested in the Constitution.
Thank you.
And then it was ratified in the elections, but then you are defending that the judges should have more power than the people in a democratic country. So why do you think that?
Well, the country, the same thing could be spoken on the other.
Sure.
Sure, thank you. Jefferson, he used his power to grant pardon on himself, thus basically becoming the judge of his own case. But if I may, just my colleague will be speaking about this after. But
Sure.
if you want me to,
No, I mean, if he's going to speak about it, then we'll hear from him.
thank you. Okay, can I? Thank you. Once we establish that the President of the United States is holding an office, then he is subject to the disqualification clause outlined in the 14th Amendment. Historical precedent and legal interpretation reinforce the notion that the President is indeed subject to the provision of disqualification clause. As I said, Attorney General Stanbury offered a nuanced interpretation of the 14th Amendment, advocating for a common sense approach rooted in the ordinary meaning of the text. His assertion that individuals who incite rebellion through speech or writing fall within the scope of the disqualification clause underscores the broad applicability of this provision. We would like to remind the court that the defendant, while he was still in office, spoke up on the official police Twitter account in a video in which he incited his supporters to take back the country, as he said, therefore falling under the spectrum of what Stanbury deemed satisfactory to justify being subjected to the disqualification clause. Stanbury's stance was echoed in 1866 by the House of Representatives, affirming that the ordinary terms used in the 14th Amendment demand an interpretation grounded in everyday understanding. As such, this interpretation extends not only to faithless state and federal officers, but also to the President of the United States, given the significance of the office and its duty, meaning that Jefferson was indeed included in this provision and is subjected to it. The logic behind Section 3 of the 14th Amendment was articulated by Judge Justin Reed of the North Carolina Supreme Court in 1869. He elucidated that individuals who have taken an oath to support the Constitution and violated it should be disqualified from holding office. This principle was applied rigorously by the North Carolina Supreme Court in...
Counsel, sorry for interrupting you. Would we be here if the President Jefferson, were to post that on his personal Twitter account rather than on POTUS Twitter account?
Well, since he was still in office and his supporters may follow the POTUS account and his personal account, then maybe yes. But it's all theoretical.
Yeah, it's a hypothetical.
Okay,
I know that, but does that mean that an officer of the United States is always 24/7 an officer of the United States just by virtue of holding that office? And so that person is just no longer a person whose fundamental freedoms, such as freedom of speech, do no longer operate?
Well, if someone is putting himself or herself in the political sphere or in the public view, then they should be held accountable for what they are saying. If a celebrity or a political figure says something, it can reach anybody, from young people to elderly people, and also about the freedom of speech. While the First Amendment protects the freedom of speech, there is a case, Brandenburg versus Ohio, that established that speech advocating for the use of force or law violation is protected unless it directly incites imminent lawless action and is likely to produce such action, which is what happened with Jefferson.
Letting you know that you have 5 minutes left in this beginning session.
Okay. Yeah.
Can we just move into discussing the pardon?
Well, I have just a little part,
No worries.
and then
Yeah.
we can. Okay.
Just know that you have 5.
So, in light of this consideration, it is abundantly clear that Kennedy Jefferson presidency should be deemed null and void, allowing an individual who had violated the oath to hold the highest office in the land would constitute a fundamental betrayal of our democratic principles. Jefferson's disqualification from future presidential election is not only warranted but essential to preserving the sanctity of our democratic institution. Anything less would be a betrayal of our nation's founding ideas and a grave disservice to the American people.
Thank you. One more question. If we get rid of Mr. Jefferson, do we proceed with appointing the vice president as the new president?
Well, since it will be a new president, maybe appoint a vice president and then do another election to let the people speak
Okay.
their mind.
Thank you.
May I also please the court? Let me remind the court how we got here. We fled the British, we fled their arbitrariness, we fled their tyranny, and we founded a constitution, our constitution, the people's constitution. The framers of the constitution had a profound understanding of what the dangers posed by unchecked power and the necessity of establishing a government based on the rule of law. Also, we retain certain elements, certain prerogatives, such as the power of pardon granted to the President of the United States. We establish a separation of powers, the checks and balances system. The power of pardon is wisely entrusted to the executive to serve as a check on the judicial system.
I'm going to jump in and ask you a question right now.
Yes.
Your previous argument with the disqualification clause relies heavily on constitutional interpretation, and then you turn around here and you have a self-pardon where there is zero constitutional text prohibiting a self-pardon. So why should we follow the Constitution down to a T when we're talking about disqualification, but not follow the Constitution's wording, which there is none, when talking about self-pardons?
The self-pardon, of course, the president is granted to pardon anyone, so including himself. So it is technically not a problem of legality. It is more of a problem, a political problem.
But would a political problem not be solved by the electorate and instead of the... Why would the courts be getting involved in a political problem? The court should only be getting involved in what I would consider a legal problem. And as you've just stated, this is not a legal problem, is it?
Yes, indeed.
It is.
No, yes, indeed, like you said.
Oh, you agree with me. Okay. So your issue then, as the American Civil Liberties Union, then is not with the pardon. Your issue is with the fact that he should not be in office in the first place.
That's the answer to the first question
Right.
of holding an office. And because he holds one for his second term, and because he self-pardoned himself, then we must respond to that question too.
You have 2 minutes, by the way.
Okay, so I'll continue. Today, so like we know, for the first time ever, the President of the US has granted a self-pardon. And I would like to remember the quote of Article 2, Section 2, reminding us the President shall have power to grant pardons, like said, for offenses against the United States except the cases of impeachment. Jefferson did allow a pardon, but on himself, and like said, and more of this, under those circumstances, the question brought before us, before this court is, can the President of the United States legally pardon himself? And the answer, like responded, is yes, because it is, by essence, a political problem. And I'll go on this. And I'll,
But Counselor,
if I can respond to
but you are representing the American Civil Liberties Union. You filed
indeed,
against the pardon.
indeed.
And so you...
No, against the self-pardon, not against the pardon itself.
But you've just said that the self-pardon is legal. Am I hearing myself
Yes,
correctly?
indeed, I did say that.
So it is.
Like I did respond
then-
to
then-
the question
then-
by saying that.
It's the opinion of this bench. I don't know about the rest, but if you're saying that it's legal, then, I mean, we'll probably agree with you. to me, it sounds like the only issue that you have is the disqualification clause, which is something that we're going to hear. But you've just agreed that you think that the self-pardon is legal. So I don't see any reason why this court would review this any further. And with that being said, your time has concluded. We'll hear a response to that in the rebuttal. We're going to hear from the respondent, please. Thank you.
All right.
Thank you.
Thank you very much.
Hello, Your Honors. Thank you for being here. And
wait, no. Continue. Sorry.
Hello, Your Honors. Thank you for being here. If it may please the court, this honorable court, today we convene here to deliberate on a case that poses fundamental questions regarding the interpretation of the Constitution and the rights of the people. Starting off with the first question, where a conviction under the 18th U.S. Code, Section 2385, for advocating the overthrow of government disqualifies an individual from holding office of the president under Section 3 of the 14th Amendment. The answer is no. First of all, it's crucial to understand the origins of the amendment, the intent of the writers, and the historical interpretation behind this amendment. This is pivotal for comprehending the legislative evolution and judicial construct. The 14th Amendment enacted post-Civil War, primarily aimed at rebuilding the nation and resolving the political assimilation of southern states. Section 3 specifically was crafted to bar former Confederates from holding public office. It's evident that Jefferson Kennedy doesn't align with this description in any capacity. More on the importance of the origins.
Well, let me interrupt you. I would say that if you are verbally supporting an attack on your own government through official channels, I would say that at least satisfies giving comfort to the enemies. I mean, you're definitely not stopping them by any means, are you?
I mean, for that, with that line of thought, confronting the rebels, so to speak, would be making the citizens of the United States enemies of the United States. There's more to this question, and I will go in depth a little bit more.
Yeah, are you just to clarify? Are you contending that a citizen of the United States cannot, in this regard, be considered an enemy of the United States?
It can, but not systematically.
Okay.
I'm going to speak on it a little bit later.
Sure.
But now I would like to also highlight the importance of the origins and the intent of amendments because of the key point of them. For example, the Second Amendment states that the right of people to keep and bear arms shall not be infringed. The intent behind this amendment was for the defense of themselves and against the state. This amendment has been subject to rigorous judicial scrutiny, and with decisions safeguarding these original intentions. For example, in McDonald's v. City of Chicago, it was reassured the right of carrying arms for self-defense. In the District of Columbia versus Heller, the right of carrying arms, it was granted for self-defense and its households. Exemplifying these cases, both reinforce the intent of our founding fathers and should be a very important line to consider at the moment of interpreting the 14th Amendment.
Apologies, Counsel. One question. You're basing your argument on an originalist approach of the Constitution. Why should this court follow an originalist approach of the Constitution and not maybe another more flexible approach like the living constitutionalism?
Thank you, Your Honor. It's a part of our argument, the origin of the amendment, but it's not the only one. Right now, I'm going to dissect the content of the amendment and pose another argument on why our position should be granted by this court. If we look at if it please the court, we'll ask to focus the content on the 14th Amendment, especially in the part that no person shall be a senator, representative of Congress, or elector as of president or hold any office if shall have engaged in insurrection or rebellions against the same, or given aid and comfort to the enemies. I would like, comparing it to the message made by via Twitter, he called upon his supporters to take back the country and restore the nation, citing his unproven claims or election fraud due to failed electors in the Electoral College. we also plead the court to see the huge difference between the established definition of insurrection and rebellion and these statements. And in no way this manifests an intent to overthrow, insurrect, and rebel against the country.
I have a question. Obviously, Mr. Jefferson has been convicted in a federal court on this crime, and the crime, I believe, and we might have to look it up, but the statute, I believe, has its own wording preventing holding office, not even constitutional. I think there's actually a piece at the end that says, yes, shall be ineligible for employment by the United States or any department or agency thereof for the 5 years next following his conviction. So let's completely, even though we're the Supreme Court, let's completely disregard the Constitution right now and talk about why we should not just be following what the law says, which is to not allow him to serve at least for 5 years. I mean, he just got convicted, so should we not at least follow this?
I'm not sure about the fragment you're looking at, but I think there's more importance about in the constitutional text and the case law established by this court than in some fragment at the end of some law.
But if you were convicted in this case, in a federal court, which has not been, the appeal on that conviction has not been successful, which means that it stands, the conviction stands, should we not, does the court not have an obligation to execute exactly as written in the legislation, which is to prevent the holding of an office or department or agency of the United States? Or is your argument that are you arguing that the president, is the president in an agency, or is he?
I would think the question is not exactly that. The question is if based on his prior conviction, should be disqualified from holding office, and that's the question is the Section 3, not what you just read. Even if hypothetically one was to interpret this statement as a form of insurrection or rebellion, which we don't stand, under Section 3, in the case of Smith v. United States, the court ruled that mere advocacy of overthrowing the government was not enough to constitute sedition, unless it poses clear and present danger. His wordings in the tweet doesn't exemplify this. In our opinion, this statement should be looked at as...
What is there a way to determine whether or not words are insightful? I feel like that's a very subjective. To me, saying let's take back the country could very much mean let's start a war.
Of course, it's very subjective, but if we look at the Twitter feed, the Twitter content, I think we can all agree there is a very far worse said inside the Twitter space and very more reprehensible stuff than the literal words that he said. Take back the country can be interpreted in many ways. Restore the nation, it can be a conceptual idea. It all depends on the ruling of this court and the interpretation of this message. In our opinion, as I was saying...
Counsel, sorry for interrupting you, but on your brief on page 10, you mentioned a pertinent distinction, in my opinion, between pardon, the legal institution of pardoning and the amnesty. And I'm just not really sure what your position is. Like, should we pay attention to the fact that there is a criminal conviction, or should we just not pay attention to that? Or is it your argument that although we acknowledge the existence of that conviction, your position seems to be not to contest that criminal conviction, your argument, if I'm understanding it properly, is just from that conviction it does not follow that President Jefferson would be disqualified as per the Constitution's text.
Okay, so thank you, Honor. The difference between pardon and amnesty, that's the first part of your question, right? My co-counselor is going to elaborate a little bit more, but I can introduce a little bit on the matter. It is important, the definition and the difference between this part. And one of them doesn't erase the crime, but just pardon it so it doesn't have consequences. These statements should be looked at under the freedom of speech, freedom of press, and freedom of political opposition within the context of political campaign. Under the First Amendment, says the Congress shall not make a law abridging the freedom of speech or press. This amendment has three main ideas. The first of it is the freedom of speech. The second one, the freedom of press, and the third one, the freedom of political opposition. Regarding the first theme, precedents such as Chaplin v. New Hampshire and AACP v. Claiborne Hardware Corporation and Walt v. United States, as well as some more, collectively established that insulting or violence-provoking speeches, clear invitation to commit illegal actions, and expressions constitute threats of violence fall outside the protection afforded by the First Amendment. Nothing in the message of Jefferson Kennedy fall outside this definition. So it should be protected by it.
Counsel, sorry, but I have another point that I wanted to mention here. Do you think that a political candidate for a political office should have the same normative standards as someone who actually holds an office? Because what you're saying is basically any American citizen is free to speak and Congress shall not prohibit that in agreement with First Amendment. Okay, we agree on that. But then why do we have specific provisions paying attention to those who actually hold offices? And how does that change? In other words, if you hold an office, are you expected to, are you set up for different standards? And if so, why should we just consider President Jefferson as another political candidate that can make up his own arguments and write his own tweets, even if they're provocative, to say the least?
Thank you, Your Honor. I agree with you. There's two different type of protections, and President Jefferson Kennedy has the right to both. One based on the freedom of speech, of his freedom of ideas, and one freedom of political stances. So it's a double protection that I would argue that is even more protection than a normal citizen. Regarding your question, furthermore, it has established by Buckingham v. North Carolina and Reno versus American Civil Liberty Union that dissemination of ideas, information, or political propaganda via internet is also protected under the First Amendment. It's a form of press, so it should be granted as a paper or as a radio show. The Supreme Court also, in the ruling in Mills v. United States of Alabama in 1966, established the principle that the First Amendment also extends the protection to political speech and advocacy. These three rights serve as a fundamental pillar in our country's principles. To assess Kennedy's action outside the purview of this fundamental principle would not only be unjust and incorrect, but also a betrayal of the ideas.
I'm going to interrupt you here. I think that, and I really like your reasoning here, but I think that we are on the wrong track, because here's the thing. He's been convicted. The conviction is there. So this is a great argument for a trial court, but not for an appellate court, because the question that we are looking at as a court right now is whether or not this conviction counts as a disqualification, not whether or not the speech that he made was inciting. The question is whether or not, if I'm convicted of advocating overthrow of government, am I barred from holding office? And what I think you're answering is, the question that I think you're currently answering is, if I make these statements, am I going to be convicted of advocating overthrow of government? That's been done. So is advocating overthrow of government considered engaging in insurrection or rebellion?
Actually, no, it's not. I might not be as clear as I mean to be, but I would like to remind the case of.
I want you to focus specifically, and I'd like for you to answer this now. The big word for me is engaged. Where's the line in engaging? Do I actually have to go and break a window at the U.S. Capitol in order to engage in insurrection, or can I engage in insurrection by sending an email that may contain, you know, some classified information, or posting, you know, a Twitter post saying, I love rioters.
Or let me continue with the reasoning of or even by omission.
Sorry?
He was referring to certain acts, positive acts, sending an email. Not necessarily an insurrection may be, you know, grabbing a rifle or a cannon, wherever, a weapon. But the president may, we're asking, even by omission, not only by action, by omission.
Yeah. So the wording used in this amendment, it's up to discussion for sure. But we can look at precedent established that remind Smith v. United States that that engagement should be clear and present, and oppose a clear danger, which
Can you repeat, what's the case? Smith v.
Smith v. United States in 1959.
Go ahead, you can continue.
Okay. How much time?
You are halfway. You have 15 minutes remaining.
Okay. Let me. Okay. Other key issue is the boundaries of the congressional authority to establish limitation to the president. Under the landmark case of Powell v. McCormack, it was established at the foundation that directly addressed Congress' power to impose additional qualifications. The conclusion was that they can't impose supplementary requirements besides the ones that were established by the Constitution. These are that be born into the United States, be at least 35 years old, and having lived 14 years in the United States. These three thresholds that the Constitution established are being met. This case referred to Congressman position. The object of the court was if a congressman could opt to the position and if the Congress itself could disqualify him. This is extrapolated to the president in a very clear way, both by the treatment that the Constitution gives to both positions, the way they attain this position through a democratic and electoral process, and the respect to the popular will. An overly broad interpretation of the 14th Amendment carries profound implications for democracy. In the case law like Griffin v. Cunningham, it's of such importance because it directly attacks the issue. Whether the political disqualification based on the 14th Amendment, Section 3 can apply. It can, but under very strict and specific circumstances which this case doesn't meet. A conviction under this section must be based on evident, direct, and directly linking the action to individuals and its actions. And the intention should be to destabilize and overthrow the government. In the same line as Griffin v. Cunningham, we can cite Bond v. Floyd, where the court discussed the elected official based on their speech and protest activity, and concluded that opposition or disagreement does not justify disqualification for insurrection or rebellion. In relation to our case, the president the president expressed an opposing view in respect to the election and the electoral college.
Can I propose a hypothetical?
Yes.
If the facts were different and the president was convicted of incitement of insurrection, would we then be able to prevent him from joining office?
Prevent from holding office or prevent to access to
disqualify?
Can disqualify once he was president already?
Correct.
Okay, I would like maybe more context or whatever, but I understand
well,
it's hypothetical.
Just instead of being convicted of advocating overthrow of government, he's convicted of incitement of insurrection. So it's different wording, but similar vibe, right? Where's the line? Where do we start? preventing people? Do you have to, is it only being convicted of treason, or are there other convictions? Can you be convicted of, can you be disqualified if you, burn down a post office?
So that's it's a tricky part because there's two sides, the judicial part and the political part. In respect to this article, the only capacity should be Congress, not the judicial system.
And Council, would you then not contest the idea that the president holds an office? What's your response to that?
So for holding,
because you're assuming, even in my colleague's hypothetical, that at the end of the day, the president is indeed an officer of the United States and holds an office. And so the potentiality of being disqualified does exist. Is that something that your argument satisfies?
It's possible, and of course it should, in some instances, should be disqualified, but I think that should be left to Congress. And the provision in the same amendment that 2/3 of the votes have to be met to make this disqualification. It could be convicted under the judicial system, but the repercussions are not the same, and the implications are also not the same.
And then what would be the distinctive element of disqualification as a legal institution vis-a-vis mere impeachment, if Congress has the last word?
If Congress has the last word, whatever Congress says, it goes.
And so why do we need two different legal institutions, meaning impeachment and disqualification?
So the objectives and the basis of each one are different, and they have a context and a way of applying it. And in this one, you could argue.
Let me ask you: are you saying that? Let's just go to the extreme. If he is convicted of treason against the United States, is he immediately disqualified, or doesn't need to go through Congress?
Doesn't need to go to Congress.
You think it needs to go through
Yeah.
Congress? So I would argue that you might be undermining the text of the Constitution, which says that you are immediately barred from holding office if you engage in some sort of act against the United States. So explain to me how you can kind of go around the Constitution. Why is it? Because obviously Congress can remove him from office, but the disqualification piece is the legal piece. Congress can't, unless they pass an act that says Kennedy Jefferson can never hold office again. Where are we getting the legal part of this? Because we're talking about the legislative part of this right now. I need the legal part, and this is why we're sitting in court today.
So
and you have 7 minutes, just an FYI.
So yeah, I'm going to maybe finish and leave a space for my partner. I think to your point, the provision that automatically he loses the position, it has quite a bit of flaws, because what makes that effective? How can it carry out this disqualification? I think Congress is of most important here, because they have the power to remove him, to condition his actions, and ultimately to fire him, if you can say so.
Sure.
And that's my part. Now I would like to leave time to my partner that we treat the second question, the second issue on the legitimacy of the president's self-pardon. Thank you very much.
Good afternoon, Your Honors. I'm going to try and make it quick. The question before us is a weighty one. Does the President of the United States have the constitutional authority to give
Is the President a citizen?
He is.
Is the President a natural person in the United States?
It is.
So why would we ever prevent the President from pardoning himself?
That's something that has been silent in our Constitution. It is imperative to note that the United States Constitution is silent on the matter of self-pardons. However, this silence doesn't mean a prohibition, leaving the issues within the realm of legal ambiguity. Our founding fathers, in their wisdom, meticulously designed a system of checks and balances, ensuring each branch performs a unique and identifiable function essential to the stability and security of our nation. The pardon power vested in the President by Article 2 of the second section of the Constitution exemplifies this equilibrium, granting the President broad discretion to pardon federal issues as this case. Even though the power has been in the president's hands for centuries, it has been used in very few matters. That is why it is something that has been used thoroughly and with conscience. Nevertheless, it is evident that this balance of powers accommodates a broader extension of the executive authority stated in our framers' intention while first drafting the Constitution, where is the necessity for a strong and powerful executive branch. This aspect has been treated in judicial decisions such as Mississippi versus Johnson, which reaffirmed the principle that the president's executive actions are generally immune from judicial review, giving this autonomy to fulfill his constitutional role effectively. As well, in Ex parte Garland, it is stated that the authority to pardon is unlimited in its applications and includes every offense known to the law on federal issues, as stated before. Additionally, the court's ruling in Schick versus Reed clarified that the pardon is an act of forgiveness, distinct from a judicial determination of guilt or innocence, establishing a clear distinction between a judge and the president.
Yeah, this is a great lead into a question that I had, which is, as far as I understand the pardon, when you get pardoned from a crime, you're actually not being found not guilty. You're actually admitting to the guilt of the crime. You just don't receive the punishment for it, and usually it gets expunged from your record. If he self-pardons and thus is basically admitting guilt to advocating overthrow of government, is that not a little bit paradoxical? Are we not now supposed to disbar him from government because he just admitted to advocating the overthrow of the United States government? Would a self-pardon not basically just... Is it not a lose-lose situation for Mr. Kennedy, is what I'm asking?
Thank you, Your Honor. That's something that I'll be treating in small, we can talk about it now. In the case of Kennedy Jefferson, the pardon was necessary to uphold the democratic will of the people who elected him as president. And that was the self-pardon on the supposed overthrow of government. As my colleague said, it was mostly on misunderstanding of his will of self-expression according to amendment of the Second Amendment. So in that case, we have the case Trump versus Anderson, which it was stated that the Section 3 of the 14th Amendment allows the candidates who are admitted as insurrectionists to run for office and even win the election to office under the Congress permission if they allow it, and that was the example here.
I got a question, Counsel.
Yes, Your Honor.
The drafters of the United States Constitution set sharply three powers and also a set of checks and balances. Mm-hmm. This way, the legislative may pass statutes. They may be vetoed by the president, but that veto may be overridden by Congress. There's impeachment, a very strong tool to control. The appointment of the confirmation of the appointment of judges. The executive power has the right to veto, and also the appointment of justices. The judiciary checks the constitutionality of not only Congress, but also the executive orders and so forth. Now, all of them are checks and balances that are initiated from one power and take effect, they fall down on one of the two remaining powers. In the case of the self-pardon, seems to me that this is a check and balance initiated in the executive power that takes effect on the same executive power. Is that does that make sense from the constitutional point and the conception of the checks and balances?
Thank you, Your Honor. That's true that considering the more strong branch of the executive power, it may make us think that we kind of get into offenses such as the nemo es supra leges and the nemo iudex in causa sua, but that doesn't mean that the executive branch wasn't constructed to have more power, because that is the power given to the president, a figure that has been going since the king's power. So it is logical that they have that power, and slightly there is a little bit of disequilibrium, but that doesn't mean the other two aren't as important as the other ones.
Your time has concluded. Thank you.
Thank you.
We'll hear a 5-minute rebuttal. Your time starts when you begin speaking.
So regarding the defense's, so the defense argued that a pardon can be granted except for acts of treason and impeachment in their brief. May I remind you that the president is sworn into office. He affirms that he will faithfully execute the office of President of the United States and will preserve, protect, and defend the Constitution of the United States. First, a self-pardon goes against the preservation of the Constitution. In fact, Article 2, Section 2 does not mention any presidential self-pardon. Therefore, adding it would contravene the preservation of the Constitution. And as a reminder, the president is not a legislator. About the protection of the Constitution, a presidential self-pardon violates once again the core of the Constitution, that is the separation of powers. Indeed, this dangerous act of self-pardoning would be the result of executive power taking judiciary's ones. Allowing Jefferson to self-pardon would place the defendant as jury and judge at the same time. Holding the president accountable of his federal crimes will be impossible, and it would disrupt the balance held by the separation of powers. Lastly,
Can I?
Yes.
I hate to bring this back up, but I'd just like to clarify for the bench here. Do you or do you not? Is your party I'm gonna turn this. Is your party trying to contest the self-pardon? Because I don't know, I was under the impression that we had agreed that the self-pardon was fine, but the problem was the fact that he shouldn't be in office at all.
Well, I'm also refuting the arguments of the defense team. So we believe that the self-pardon, as my colleagues say, if I just can clarify a little bit, he said that it was a political problem, but it's not just that, and it's also because it's sorry.
No, you're good.
It's not only a political problem, it's also just judiciary one, because it concerns the president and because it comes from his conviction under US 18 US code.
But do you think that this should be something that the court decides, or something that Congress resolves?
Well,
because it sounds to me like we just need a constitutional amendment to be passed by Congress clarifying whether or not you can self-pardon.
The problem is that it's well, since it's the first time that it's happening, we couldn't know that, and since it comes from his conviction, as I said, then it is our belief that we have to take position on the matter.
Okay, 2 minutes.
Thank you. Holding the yes, I did this part. Sorry. Lastly, the president swears to the defense of the Constitution. Once more, and I firmly insist, the democratic pillar of the Constitution is the separation of powers. It is of his duty to put his heart and soul to defend the checks and balances system. Therefore, the unimaginable act of a president's self-pardon would undoubtedly breach the oath he faithfully took, constituting no other than an act of treason. Minimizing the consequences of a self-pardon shows the poor esteem the defense have of the checks and balances system, the pillar of the U.S. Constitution. Regarding Jefferson's conviction under 18 U.S. Code 2385, the defense came in this court to convince the judges that this conviction goes against the right to freedom of expression granted in the First Amendment of the Constitution. They seem to forget the limits to that right. As I said, there are precedents limiting this freedom because it does not include the right to incite imminent lawless action. As the defense team seems to have forgotten the facts, I would like to remind them the dangerous behavior of Jefferson's actions, where the incitement to act violently is undeniable. He released a video on the official Twitter account where he urged his supporters to take back the country. What other ways, except through violence, could be considered to take back the country? Are words not considered weapons? This call to action sparked nationwide protests, with supporters gathering at the Capitol building. The demonstration was violent as protesters breached security barriers and engaged in acts of vandalism. The defense strongly expressed the importance to protect the nation. How could they normalize these acts of vandalism? Jefferson actions.
Your time has concluded.
Okay.
Thank you.
Thank you.
With that, we have heard arguments from the petitioner and the respondent. The court will meet in session and the results will be announced at the end of the day. Thank you.
Thank you.
We will call the next case. We will come to session in 20 minutes from now, 450. Presenting docket 11-1323B, American Civil Liberties Union versus Kennedy F. Jefferson. Is the petitioner ready to proceed? Yes. Respondent? Yes. Lovely. Before we begin, you'll be given 30 minutes and 30 minutes. However, the petitioner reserves the right to reserve 5 minutes for rebuttal. Would you like to reserve all 5 minutes?
We would like to reserve 4 minutes.
4 minutes for rebuttal. So you'll be given a speaking time initially of 26 minutes. The respondent will have 30 minutes. I will only be telling you when you have 2 minutes remaining. I will not assist you in any other timing. You may ask at any point how much time you have. You are welcome to keep a running timer yourself at your desk if that helps you. No computers on the podium. Any questions? Wonderful. Petitioner?
Hello, Your Honors. We are here on behalf of the petitioner, the American Civil Liberties Union, to question how or to challenge how the self-pardon that Kennedy Jefferson is attempting to use is constitutional, it's unconstitutional. In addition, the Section 3 of the 14th Amendment prohibits the defendant from holding office. To give a brief context of the actual situation at hand, Kennedy Jefferson was the President of the United States, and his defeat in the 2016 elections was not solely a presidential loss, but rather he lost sight of democracy, inciting himself a horror that attacked the very office he swore to protect. After he lost to Jacqueline Rockefeller, he took to his social media to storm and plead the American people to, quote, take back the country and restore the nation. Due to his actions, he incited a mob protest that stormed past Capitol Police, assaulting police officers and a Democratic senator. Arson and assault are only a handful of horrible events that happened within this, and military intervention was necessitated. The Green Party did try to impeachment. However, he was acquitted arguably because the Libertarian Party held Senate majority, a decision that contrasted a crime proven by evidence of his involvement. Nevertheless, Jefferson was later convicted of advocating to overthrow the government under 18 U.S. Code 2385 during his 2020 re-election campaign. Therefore, even though he managed to secure the spot of president again,
Counselor, I'm going to go ahead and interrupt you right now.
Sure.
Are you speaking on the pardon or are you speaking on the disqualification or both?
I'm giving a summary of the events.
At
this moment, I am talking about how he is ineligible to hold office. However, we will first be beginning with the argument on how the execution of the self-pardon itself is unconstitutional.
Okay. Yeah, I want to ask you a question about your brief. You mentioned you just mentioned the conviction under U.S. Code. Are you familiar with the text of that that statute?
Yes.
Okay. You are aware that the statute has a clause within it saying that you may not hold office for 5 years after being convicted of that. Completely separate to the Constitution, I just want to get it out of the way. Do you believe that we should be following that disqualification over the constitutional one, or should we be?
No, because the order of U.S. law is that constitutional provisions come first. In this case, the Constitution has specifically insisted that he is not eligible to hold office, and thus the Constitution is the supreme law of the land, and therefore we should prioritize that within this case, and that is what we will be advocating throughout. So first, let's begin with the originalist interpretation, how the originalist interpretation of the Constitution demonstrates how the self-pardon is unconstitutional. And to properly address this, we need to identify the historical and originalist context of its interpretation. We can see this as currently under Supreme Court Chief Justice John Roberts, the Supreme Court inhibits the era of judicial restraint and constitutional conservatism. Whereas the issue of self-pardon attempts to broaden the interpretation of Article 2, Section 2, which was not the originalist interpretation as of the Founding Fathers, because they created the Constitution with the idea that the president was supposed to uphold the democratic virtues of the new republic, not be the cause of its attempted collapse. Therefore, to first preface and give a foundational idea of this, we would like to begin with referencing the Constitutional Convention of 1787 by James Madison. He explicitly stated that a president should have the power to grant reprieves and pardons except in cases of impeachment, and this demonstrates within itself the early concern of the president trying to use this power and potentially the early deliberate effort to prevent the president from using this power to obstruct justice in cases that potentially involve himself. And while the respondent may come and say that because the Constitution does not include it specifically, the fact that it goes unmentioned within itself speaks volumes. Because the Founding Fathers created a specific system of checks and balances so that the executive power can be limited. Michigan Law School professor Colt, a widely known scholar, believed that the founders either thought that the self-pardon was 1, unattainable, or 2, never considered it. And even if they never considered it, it remains outside of their original interpretation. And to prove the claims of the Founding Fathers' explicit intentions, we can refer to Federalist Paper number 69, where Alexander Hamilton highlighted how the president's authority is far more circumscribed. It is intended to only serve the public good and not to enable self-aggrandizement or the evasion of justice. His conviction of insurrection certainly did not serve the public good, and frankly, it would be an self-aggrandizing and an evasion of justice if he tried to pursue it as so he speaks. And to further this, the Federalist Paper 74, we can see that he further argues that the pardon power should be exercised with the primary goal of tempering justice with mercy, perhaps especially in cases of sedition, where people may have been prosecuted with undue severity. While the respondent may propose that this clause is broad and unencumbered, we tell you that this clause is broad and unencumbered for those who fall into the category. Therefore, the president is not within the category, as he was not undue or severely prosecuted, and if anything, he was not prosecuted enough because he was not impeached. Many argue because he had a Senate majority, and Jefferson is proven guilty of the crime, U.S. Code 18, Section 235.
Counsel, the pardon power allows for pardoning of any United States citizen, natural person. Why is the president himself not considered a United States citizen, natural person? I think both of those criteria are satisfied, so I don't see why we should be prohibiting self-pardon if there is nothing in the Constitution, as you've mentioned, that prohibits it directly.
Well, because the idea is that it was vested in the president to give pardons to other U.S. national citizens. The idea was that it can be tempered with those who are unfairly prosecuted by the court itself, and therefore he, as his executive, can check the power of the judiciary.
So it serves as a protection of citizens' rights. But who is protecting that citizen's rights? The president. In that case, would we not need to grant some sort of pardon power to the vice president to pardon the president? If there's nobody who's able to pardon the president, then in reality there's only one person in the United States who's not protected, and that's him.
Well, if the president was not president, let's say it was Jacqueline Rockefeller, she could then go ahead to pardon him. However, this is not the case. He is trying to give himself something that he cannot give himself, and thus it invalidates it. He is a citizen, but in this position, he is the president. The president was vested the power to give it to other U.S. citizens, not those that are meant to preserve this certain thing. Again, and also the executive cannot check the balance of the own executive. In this case, the pardon power was vested so that he can check the judiciary's power. In this case, what is trying to be argued is that he cannot check his own power with that pardon. And in that idea, with the strict separation of powers, we can see how it's underlined in Marbury v. Madison, because the judicial branch directly checks the executive power, because Justice John Marshall did not grant Marbury's requested relief because it was.
I don't consider this a check on the. I don't consider it the executive checking the executive. I consider it as still the executive checking the judiciary as a private citizen. As a private citizen, you're being convicted of a crime, and you need some sort of pardon to be able to protect yourself from being convicted. So, yeah, I see him pardoning himself as him acting as the executive, checking the judiciary, but not. It's not self-serving the executive. It's not like he's. He could just as easily pardon the vice president or the governor of Maine. I mean, I don't see it as. I want you to tell me why it's not. Why is this checking the executive and not checking the judiciary?
Because one, in this case, if he was to pardon himself, it'd be self-aggrandizing, and it'd be just enabling injustice. Not only that, but it effectively put the president above the law, because he cannot check his own power. Yes, you can argue that he can be any other citizen. If he was, let's say Jacqueline Rockefeller was the president, she could then pardon him later on. However, in this case, this was the strictly demonstrated by the Federalist Papers as well as the Founding Fathers that the Constitution specifically wanted this as to protect against the judiciary, which could happen if President Rockefeller or someone else was the president and decided to grant him that pardon.
But I mean, we are all sitting here as Supreme Court justices right now, and for example, we abide by a code of ethics that is created by us. Is that not? But we're allowed to do that, so why can't he pardon himself? If the judiciary can regulate the judiciary, why can't the executive regulate the executive?
The judiciary may regulate the judiciary, but there are other measures in place that regulate that check the balance of it, because realistically,
but is that not why we have the impeachment process and the removal process there? That is the check on the pardon power to me.
Yes, it could be considered as one of them. However, there's not only one system that is a branch that is there to check a power, and therefore we cannot rely on one system, which we can potentially argue that it may have failed us in this case. He did have the Senate majority, and therefore we have to exercise other ways of checking the power to ensure that justice is served. And furthermore, when you're saying how, why can't the president pardon himself? This was a power vested in him to give to someone else, to give to a U.S. citizen, to give. In that time being, even forgiving yourself is a concept of modern psychology. You don't just say, I'm going to give something to myself. Especially the Founding Fathers would never consider this interpretation. And thus we believe, because it is outside of that interpretation and that scope, it is therefore an invalid claim.
Counsel, sorry, okay. Would you see acceptable if, for instance, the president took a temporary leave for 24 hours, the vice president takes the office of president, and then now President Rockefeller pardons seizing President Kennedy Jefferson? Would your conclusion change in that case?
I think that would be a different case that we would be trying, and two, he technically would still have the role of president, and thus that would have to be if he completely stepped down from his role to the point where he doesn't even have that president title. Therefore, that would be another argument that we could pursue. However, in this case, he holds office himself, and therefore we cannot conclude on whether the vice president could then pardon himself, as that perhaps is outside of the scope of what the case that we are trying today. And also, the respondent has tried, in this case, to use the pardon power, the respondent has tried to widen of what it was actually entailed by using Schick v. Reed to say that the pardoning power, yeah, of course.
Good. Sorry. Sorry for interrupting you, Counsel. The drafters of the Constitution designed the Constitution in the three powers, dividing the three powers sharply, but also having some checks and balances, and this case involves some of them. I wonder, can a mentally ill person be president? Because the Constitution doesn't say anything. Or maybe we could ask ourselves if a convicted child abuser, could he be president of the United States? The Constitution says nothing. And I think that the Founding Fathers would not like the idea of these individuals becoming presidents of the United States. I wonder if they referred to the check and balance of the American electorate, the American people judgment on that. What do you think about this?
I think to compare a mentally ill person and a child abuser, one or two completely different cases. The mentally ill person, we can argue they're on medication. There are certain things that could actually enable that. Number two, the child abuser. It might not be said in the Constitution. However, if he was to commit that during, it could be idealized as treason.
We understand that specific sentiment, but I think what my colleague is asking is why, if we had a child abuser who came into office, or we had someone who was in severe, mental discapacity, was not able to run office, yes, that in that specific regard, we have to leave it to the voters. So why are we now intervening in this specific case? To me, advocating is speech. It happens all the time. I could advocate right now to, go to the cocktail, but it's not necessarily meaning that we're all going to, go to the cocktail. So I don't know. I agree with the bench here, and so I'd like to hear your thoughts.
I completely understand your point, and before I pass it on to my co-counsel, I like to specify if he was incapacitated, if he's in a specific case of incapacitation, as you were saying, the VP would take over, 1. 2, when the electorate is voting, they are not 100% sure that he's going to go and self-pardon to do something that is not only unprecedented, but we have proven unconstitutional. Therefore, before I finish this, I'd like to pass it on to my co-counsel.
Well, here, just one more thing. This is interesting because the president becomes incapacitated, and the people who initiate the vice president taking office is actually the president's own cabinet. That's the executive checking the executive. So I think that maybe supports what I was talking about earlier, which is why I don't think that there's an inherent problem with internal workings of the executive supporting the functions of the executive. And I'd like to hear more of your thoughts or your co-counsels.
My co-counsel will broaden off of that about how the VP and other people of the executive taking over, rather than the president trying to give himself something as the executive to the executive, are two completely different situations.
Okay.
Thank you.
Good morning, Your Honor. Before I go into depth of the cases, how the scope of the power was extended or limited, but still hold the same values, I would like to relate to the question asked before to my co-counsel about why president shouldn't be judging in his own case. And here I think we already see the point, which is the rule, no one should be the judge in their own case, which is a crucial rule in both common law and natural law. If the president was handed the self-pardon, it would allow him to go beyond the rule of equality of law, as he would be in the capacity to give pardon to himself, serving his interest. And we see that this is a thinking that we can spot globally. For example, we can look at the case of Rohana BTA Arifin versus University Saints Malaysia, where there is the statement that Rohana shouldn't be expelled from the university if the decision by the committee included members involved within the events leading to her expulsion. And that reasoning comes from the fact that no one should be the judge in their own case, as Nemo Judex in Casua states. That means that the pivotal rule of law means that if the president was granted the power to pardon himself, he could be able to play in his own self-interest, and there would be, it would underlie the independence of the judiciary.
Counsel, if I may, I see that your entire oral argument is focusing on the second question that we have before us, which is on the nature of the self-pardon. However, isn't the self-pardon question already dependent on accepting that there is no disqualification in place? What is your position on that?
This is something that my colleague will cover in the second part of the argument. However, we are not trying to take away the office of the president. We're most specifically just trying to underline that the self-pardon was not constitutional in this case.
You're not.
No. We are, and next we will show how he's next we will show why he was ineligible for the office in the first place. Looking at the impeachment, because the lack of precedence of self-pardon is not a gap in the law. It is a result of the fact that it goes against the rule of law by allowing the president to decide cases where the conflict of interest is on the base of the rule. And such argumentation aligns with the reasoning of Richard Nixon's legal team when the former presidents faced charges related to the cover-up of illegal activities within his administration. And here allow me to quote Acting Assistant Attorney General Mary Lawton, which concluded in her memo in 1974 that under the fundamental rule, no one may be a judge in his own case. So it would seem that the question should be answered in the negative when considering allowing the President Nixon to issue the self-pardon.
Counsel, why is this a problem of separation of powers? I don't see it. The origin of this conviction is judicial by nature.
Yes.
It's judicial. And so the executive power is intervening to correct a judicial decision.
But as we see here...
And do you want us back to the judiciary power to correct the correction made by the executive power? In other words, I mean, how can this be in accordance with the rule of law if we're actually reviewing the revision of one of the decisions of the judicial power? In other words, I think that the pardon as a legal institution is created and designed in one way that we extend and we grant the executive power a very wide range of discretion. And in this case, you're telling us that that discretion is too much. And if so, how can we measure when is it too much and when we should overstep?
The power of the presidential pardon was established in order to grant mercy and temper justice with mercy. However, it also implies that the executive power is non-biased and is trying to serve the public good, as also Hamilton stated in Federalist Paper number 74. And here we see that if the president was allowed to grant himself the self-pardon, he would act on his own self-interest. And of course, the defense may state that being the executive as the head of the state is not necessarily linked to being an individual of the citizen in the United States. However, by the definition, it's still granted in one person's power. This is the prerogative of the president. So we are speaking here about the individual and not the executive power. And before we move on, how much time is left?
You are at 20 minutes, so you have 6 minutes remaining.
And now I would like to let this argument be continued by my colleague, who will show why the president is not eligible for the office in the first place.
Honorable Justices of the Court, now that we have established the unconstitutionality...
I'm sorry, I'm just going to jump right into it, okay? The language of the Section 3 of the 14th Amendment has a specific word that I'd like you to focus on, and that is engaged. Tell me a little bit about how advocating, which is in the name of the conviction, advocating for overthrow of government, is considered engaging in insurrection.
Well, engaging is a very wide-encompassing word. Engaging doesn't necessarily mean physically being involved. Engaging can be literally being engaged means to be involved in any sort of capacity. Therefore, advocating is very much engaging. It is being involved in the process of an insurrection. We would like to establish that the unconstitutionality of self-pardon is also simply void. The self-pardon was void due to the lack of a legal foundation. We would like to demonstrate the defendant's ineligibility for office as per Section 3 of the 14th Amendment. First, we look at the historical context of the 14th Amendment, and although it was drafted in 1866 with the original intention of keeping out Confederate officers and generals from positions of political power, we can also see that at the time, the drafters also mentioned the wider comprehension of the amendment's role. For example, John A. Bingham of the Joint Committee on Reconstruction at the time. Quote, the amendment was designed to secure to all the people the rights of life, liberty, and property, and their pursuit of happiness, end quote, showing that the amendment, Section 3 of the 14th Amendment, showed a commitment to safeguarding American democratic institutions, not just keeping out Confederate former officers from positions of political power. We can also see that a wide interpretation, therefore, is not overreaching. It is simply following the intentions of the original drafters.
Councillor, would you agree with the statement that the United States Constitution designs the United States as a militant democracy? Because that's what it seems to me when what you try to argue here is that the Constitution has legal mechanisms to protect itself. Is that actually true? And if so, where do you find it?
We do not wish to argue that the Constitution has mechanisms to defend itself. We are simply saying that the Constitution has a wider interpretation than just, for example, protecting the democratic values of the United States, which are not just in the Constitution but also in documents such as the Declaration of Independence and generally all the documents that have led to the creation of the United States of America. The Constitution has supreme authority concerning the qualifications for federal office, and we have seen this in cases such as, for example, Powell v. McCormick, where after being elected to the House of Representatives, the House denied membership to Powell. However, the Supreme Court ruled that the House does not have the constitutional authority to deny his seat as he met the criteria established in Article 1 of the Constitution.
I'm sorry, I'm going to have to interrupt you. I'm really having trouble understanding why we are taking to me, I can't get past the fact that the conviction was on speech-based items. I mean, and in this case, you're basically saying any time that a president during the course of their campaign for re-election speaks negatively about the current situation or about the institution as a whole, we can now disbar him from ever holding office again?
This was not just negative speech. This was clearly very emotional speech that was intended to his supporters in a video after months of claiming that the election was fraudulent and that the results were not true. And therefore, given the context of the events, it was absolutely greatly raised the likelihood of these words ever leading to a violent insurrection. Therefore, it was not just negative words. It was also, given the context, it was more than just the words. We can also see that in U.S. Thornton, U.S. Term Limits Incorporated versus Thornton, there was a challenge to an amendment to the Arkansas State Constitution. However, the United States Supreme Court ruled that only the only eligibility set out in the Constitution is legally pertinent to.
Section 3 bars people from holding office in a department or agency of the United States.
Yes.
I personally would not consider the presidency as an agency or department. I would consider that as the United States. So
yes.
Explain to me how he falls within the scope even of this article.
The defendant fulfills all the formal criteria set out in Section 3 of the 14th Amendment. First of all, the defendant is an officer of the United States. So, for example, as we can see, in George Washington, when addressing Congress in 1797, he called for legislative revision of compensation to officers of the United States. A few months later, the Congress passed a bill to revise the salaries, including the President of the United States, clearly stating that he is an officer of the United States. Secondly, the defendant also has taken an oath to uphold the United States Constitution, although the oath is to protect, to preserve, protect, and defend the Constitution from Article 2 of the Constitution. It falls under the auspices of the Section 3 of the 14th Amendment. An oath to preserve, protect, and defend is viewed as equivalent to supporting the Constitution. It is not possible to support the Constitution without preserving, protecting, and defending it. The defendant is also guilty of advocating for insurrection against the U.S. government. This is his culpability is determined through his violating 18 U.S. Criminal Code Section 2385.
Counsel, so suppose that you have a natural person,
Yes.
a citizen, committing those crimes and convicted for those crimes. That person would not be subject to the 14th Amendment, Section 3, just because they're not holding an office of the United States. Is that correct?
And you're going to answer this question, and then your time is concluded.
The Section 3 amendment of the 14th Amendment applies to officers of the United States. Yes.
Thank you, counsel. We'll hear from the respondent.
Honorable Justices, and may it please the Court, my name is Catherine Del Rio, and I, together with my co-counsel, Electra Sarafopoulou, represent the respondent, President Kennedy Jefferson. Today, we stand at the crossroads of constitutional interpretation, where the fundamental principles of our democracy intersect with the exercise of executive authority. At the heart of the case lies two questions of immense significance. Does the President of the United States possess the inherent right to pardon themselves? And does President Jefferson's conviction under U.S. Code Title 18, Section 2835, make him ineligible to hold office of President? First and foremost, let us remember that the Constitution is the supreme law of the land. It is the cornerstone of our democracy, the bedrock upon which our legal system stands. Nowhere within this sacred text does it expressly prohibit.
So I want to start there. You say nowhere does it expressly prohibit, so thus we should allow them to self-pardon. I think that's a very dangerous way of interpreting the Constitution, because the Constitution doesn't say a lot. And if we start just saying, well, it doesn't say we can't, so now we can, I feel like that's a very dangerous precedent to set.
I would like to address this with the Latin phrase, expressio unius is exclusio alterus. The petitioner claims that through the lack of mentioning that self-pardons in the Constitution inherently means that it is prohibited under the Constitution. However, the strict language and the strict language makes it evident that the Founding Fathers limited strictly the pardoning powers to cases of impeachment and only to state crimes. Therefore, the presidential pardoning power is unlimited in terms of federal offenses. Okay, sorry. And our esteemed Founding Fathers entrusted the President with significant powers, including the pardoning powers, as a means of promoting justice, reconciliation, and for the public good. While the specific issue of self-pardons may not have been expressly addressed by the framers, the principles underlying the pardon power, namely the authority of the executive to grant clemency and mercy, are consistent with the broader goals and aspirations of our Constitution. It is imperative that we recognize the President's rights to pardon and that President Jefferson exercised this right well within the constitutional limits. The pardon power is not a mere privilege. It is a solemn duty entrusted to the executive by the framers of our Constitution. To deny the President the ability to pardon themselves would be to undermine the very fabric of our democracy. This case represents a grave injustice, not only to the President, but to the principles of fairness, justice, and the rule of law. It is
But Counselor, if I'm going to go to a courthouse and I'm going to sit in a trial, I am probably not going to see the defendant sitting in the jury box as a juror on their own case. So why are we seeing the President determining his own fate here?
I believe that the petitioner's argument is quite flawed in the sense of being a judge in one's own case. The pardoning power is strictly a political power, not a judicial one. Therefore, it is not pardoning power if the President issues a pardon to another. They are not changing the verdict issued by the judicial system.
So you're not changing the verdict, which means that you're convicted under this title no matter what, correct?
Through President Jefferson's self-pardon, he is not changing the verdict found...
So he's found guilty. So in the text of the statute, it says that he cannot hold office for at least 5 years, and that's in the statute. That's not even a constitutional interpretation. The court has no ability to interpret that because it's statutorily obligated within the sentencing guidelines of that piece. So what you're saying is that this self-pardon by the President is going to disqualify him from office at least for 5 years. Maybe not indefinitely, but at least for 5 years, which means that, in turn, he should not be held in office, and in turn, that self-pardon is null and void.
Your Honor, I would like to address the petitioner's argument, which stated that they don't believe that the statute of preventing the president for 5 years is the supreme law of the land. The Constitution is. And nowhere in the Constitution does it state that there is a limit on when a president...
Okay, just for when this argument is developed further, I would be happy to discuss the difference between a pardon and then amnesia, and an amnesty, which means erasing, not pardoning. All right, good. Continue, please.
Regarding Your Honor's statement about the changing the verdict, the pardoning powers are to exercise mercy on individuals who have fallen victim to undue severity by the judicial branch, and also to promote justice, fairness within the United States governmental system.
Counsel, and so that promotion of those values, let's say public values, by the executive is, at the end of the day, an executive measure, an exercise of political discretion that is granted on the executive power.
Yes.
Is that correct?
The constitutional power to pardon is given to the president with presidential prerogative. It is up to the president's discretion on which case and when to exercise this pardoning power.
Is that discretion limitless?
Yes, according to the Constitution, it is limitless.
Are there other regulations or decisions made by the president that escape judicial review?
Could you please elaborate?
So if this is an executive decision and the executive has discretion to make their choices in terms of policy preferences and how to interpret the public values, does that preclude judicial review of that? In other words, we cannot enter into the merits of the decision, so we cannot understand or we cannot second guess the interests of promoting some public values by the executive, and that's fine, but our rule of law mechanisms protect a judicial review of those executive decisions so that we empower individual citizens vis-a-vis or before abuses of power.
Absolutely, Your Honor. The entire system of the United States government works on the partial separation of powers, which implies that checks and balances over the different branches of government are exercised. For example, pardoning power is a check over the judicial power. But this does not mean that the executive is without any checks nor balances. Congress, the legislation, has the ability to begin impeachment proceedings as they see fit. And this was seen by Congress beginning an impeachment proceeding for President Jefferson. However, he was eventually acquitted.
So it follows that if you wanted to disagree politically with the decision made by the executive to pardon even himself, you would have to take a political route vis-a-vis voting him out. Is that okay? Is that correct? Is my understanding correct here?
Yes, the Constitution outlines the means to remove a president, and this is done through impeachment proceedings if the president is found guilty, and then that gives grounds for the removal of the president.
So in the end, who is the one that decides the eligibility for president? I mean, we saw in Trump versus Anderson that states are not allowed to. I think, was that Trump? It was one of those. That states were not allowed to choose who was on the ballot, right? Is it now our job to review every president for whether or not they qualify under this article, or is it a decision made by Congress?
Your Honor, it is a decision made by Congress. Congress is the body responsible for ratifying the Electoral College and swearing the president in. If the Congress has any issues regarding the eligibility of that candidate as holding...
We agree. That's what I'm saying. But we're in court right now with a presentation saying that you want the court to issue an order taking the president out of office. So why, if you agree that Congress is the one that should be making the decision, why is Congress not the one making the decision? Why are we sitting here?
There is no doubt that the Supreme Court holds immense influence over
potential proceedings of other bodies of the government. So, but this does not result in the Supreme Court having ultimate final say over the case like this. It is at the end of the day, it is up to the Congress to listen to the Supreme Court ruling and file an impeachment proceeding if they see fit. However, that is still up to the Congress and the Senate of determining whether, after the impeachment trial, of convicting the person or acquitting them.
Okay. You have talked about checks and balances, correct? The Constitution was drafted sharply in the three powers, okay? And also a set of checks and balances in between, some of them quite subtle. Anyway, so we see here, for example, there are judicial checks. There's judiciary review for the acts passed by Congress. There's judicial review for executive orders, so they can be reversed. The executive also may veto legislation passed by Congress. The executive appoints justices to this court. Okay. The legislative may reverse the veto of the president with a majority. May impeach. It's a very powerful correcting tool in a very presidential system in the Republic. All of this balances, as itself it talks, they are initiated by one power and they take effect on the other. The practical effect is in the second, in one of the two remaining powers. In the case of the self-pardon, it seems to me that this is one balance that comes from one power and takes effect on the same power.
Your Honor, you have noted how the checks and balances work in the U.S. governmental system. However, I would like to point out that allowing self-pardons will maintain the separation of powers by affirming the executive branch's constitutional ability to check and balance potential abuses and overreach by the judicial branch. It ensures that the president has the means to defend against politically motivated or unjust prosecution.
Excuse me, if we go on, John Locke, as inspiration of for the Constitution, no individual should possess the three powers of making, enforcing, interpreting laws, as this concentration of her authority undermines the fundamental principles of liberty and justice.
Yes, Your Honor. However, it must be noted that self-pardons are not having that entire authority. It must rely on the judicial, and if, using presidential discretion, if the president sees that there was a potential overreach of judicial power, they may exercise mercy through the form of a pardon.
But in this case, we see that there was a statute, a federal statute passed by Congress stating a crime. There was a judiciary who interpreted and who apply such act, and there is the president who. The now president who was convicted. He was convicted. And now he has the pardon. In other words, he has the right to reverse the rest of the two wheels of the two remaining powers. Is that it?
However, yes. However, Your Honor, it must be noted that that is how the system of pardoning works. Just because it was issued to the president by himself does not mean it changes the entire structure of the pardoning. Pardoning is a constitutional authority given to the president by the founding fathers to exercise the clemency over potential cases. I would now like to delegate the rest of the time to my co-counsel, Electra Sarafopoulou.
Thank you, Counsel.
Honorable Justices, and may it please the Court. Today we are dealing with a landmark case, one which directly puts to question the authority of our great Constitution and the principles that we, as a nation, pride ourselves upon. We contend that assuming a conviction under the U.S. Code Title 18, Section 2385, automatically results in President Kennedy Jefferson being deposed from office would mean that we are disregarding the clear requirements laid out in Section 3 of the 14th Amendment, as well as the First Amendment's free speech protection and the power of the electorate. The trial rests upon upholding the integrity of constitutional supremacy, and such deprivation of a president's rights would be a contradiction to the democratic principles that are at the core of our political institutions. Your Honors, I urge you to see that the case at hand is baseless. Disqualifying President Jefferson under Section 3 of the 14th Amendment would be reconstructing the meaning of our Constitution and completely disregarding the strict requirements laid out not only for running for office, but also for inciting an insurrection. I would like to begin by outlining the inherent difference between U.S. Code Title 18, Section 2385, and Section 3 of the 14th Amendment. The latter is not a criminal penalty, but rather a qualification for holding public office in the United States. Since President Jefferson does not meet the requirements necessary to be disqualified under this clause, regardless of his previous conviction, it does not stop him from running, being elected, and holding office. There is one element which is included in Title 18 that is not in the 14th Amendment, which is the notion of advocation. The 14th Amendment requires that a person can be disqualified for having engaged in insurrection, which implies an action. In the case before us, it is evident that President Jefferson did no such thing. We contend that even if his words were provocatory, they do not only lack disqualification under the 14th Amendment, but are also protected by the First Amendment.
Counsel, crimes may be committed by action or by omission.
Crimes may be committed by both action and omission. However, in the case before us, we are dealing with disqualification. It would be double jeopardy to consider the conviction under U.S. Code Title 18, Section 2385 once again, under which the president has already been convicted.
Interesting.
I would like to begin by outlining the inherent I would actually like to continue by considering the rule of law, which ensures that we are all equal under the law, and the president here is no different. He, like every other citizen, has constitutional rights. One of the most fundamental, the First Amendment right to free speech. Preventing a president from holding office due to tweets would not only directly contradict the Constitution, but would pose grave threats to the rule of law that lays at the forefront of our democracy. The Supreme Court has set an extremely high standard to restrict free speech. Jefferson's words are protected under the First Amendment as a result and do not qualify as incitement to imminent lawless action under Section 3.
Counsel, do officer holders in the United States have a different normative standard of behavior, of professional behavior, of observing some norms that are just not merely legal but also behavioral?
To an extent, yes. However, this does not stop them from having rights under the US Constitution. What they have to do is uphold specific principles of our system. And President Jefferson, under no case, if we are to consider the facts, did this.
In your opinion, is President Jefferson a U.S. officer?
We would like to consider that he is a U.S. officer. Even if we consider he's a U.S. officer, he will still not meet the requirements under Section 3 of the 14th Amendment.
So are you saying that, because he was convicted, we can't argue that he wasn't convicted of this crime, right? So are you saying that advocating overthrow of government does not satisfy engagement in this regard?
Yes.
You are saying that?
I am saying that there is an inherent difference between the two, and Section 3 does not include advocation as a reason for disqualification of candidacy and for holding office.
Counsel, does it make any legal difference to use an official Twitter account to actually make those provocative statements, as you call them, rather than a personal, private Twitter account? Does that make any difference from a legal point of view?
President Jefferson did use the official Twitter account of the American government to post these tweets. However, I would like your honorable judges to consider that even if he used this account, it still will not qualify him, and he still has First Amendment protection. And even if we consider the context of what happened after the tweets were posted, he will still not qualify as a person who has incited insurrection. And this is specifically stated in Bible Believers, where the court actually found that even with a context of having violent actions afterwards, we cannot hold that the actions of other individuals make the president's speech any less protected. And similarly, if we also consider Snyder v. Phelps, in which it affirmed that the principle of freedom of speech, especially on public issues, is protected under the First Amendment. Even if it is considered offensive or hateful, Jefferson's speech would be protected. And the expression of such controversial or offensive opinions to some individuals, even those potentially related to insurrection, are protected unless it meets the criteria for incitement to imminent lawless action as established in Brandenburg v. Ohio. I would like to continue by stating that even when we consider the First Amendment right to free speech, we have to also consider Hess v. Indiana. The petitioners tried to claim that the president has incited insurrection. However, in Hess v. Indiana, it is found that first, that speech is protected under the First Amendment if it did not explicitly advocate for violence or lawlessness, which is what happened in the case at hand. The interpretation of the speech of other individuals does not make the president's speech any less protected.
I'd like to kind of switch gears a little bit and draw your attention to, in Section 3, you have the engage in insurrection piece, but then you also have anyone who gives comfort or aid to enemies of the state. I would argue that at the very least, the saying let's take back our country and everything and being convicted under that statute is at least giving comfort or aid to enemies of the state.
I apologize, Your Honor, but I do not agree with this statement.
Well, let's hear it.
And specifically considering what I just stated, which is when the Supreme Court decided on the case of Hess v. Indiana, it stated that there has to be an explicit advocation for violence or lawlessness to be disqualified under Section 3 of the 14th Amendment and to not have free speech protection. And this isn't the case at hand, because the mere tendency of speech to encourage unlawful acts is not sufficient grounds for restriction. I would now like to continue by considering the principle of free democracy and impeachment. And it is paramount to not understate these principles. Free democracy is the principle which underpins the power structure in the nation. All powers derive from the people. And this is emphasized both in Trump v. Anderson and Bond v. United States. The people voted.
Counsel, then how should we interpret the words given aid or comfort? Are those two things equal under Section 3 of the 14th Amendment? Because I think that like following my fellow justice, I think that echoing a sentiment that is somehow not anti-constitutional, but certainly disruptive of constitutional harmony might actually constitute what the amendment requires or calls comfort to the enemies thereof. Perhaps not given aid proactively, but given comfort, meaning echoing those feelings from an institutional account, from an, as you said, a US officer that should represent every citizen and should actually promote the values of neutrality, meaning institutions include everyone, not just the followers or the supporters of the holder of that office. So how should this court interpret if we have to make a distinction between giving aid and giving comfort of the enemies of the United States?
Thank you for your question, Your Honor. I would like to draw this court's attention specifically to the case that we have at hand and how this interpretation would affect the case that we have. President Jefferson did post some tweets on a public Twitter account of the US government. However, I must once again reiterate that the reaction of his supporters and the actions that followed, specifically his tweets, could not make his speech any less protected, and therefore he could not have been disqualified under Section 3 of the 14th Amendment. And this is specifically seen if we consider...
What is the line? Like, what would be giving aid and comfort in that case? Can you give me an example, a hypothetical, of what would be giving aid or comfort to enemies?
An example would be, I would like you to go riot in the by the White House and take back the country to ourselves. That would be explicit intention to incite imminent lawless action. However, I think...
Thank you.
Yeah. I would like to once again draw this court's attention back to the principle of free democracy, and specifically how the independence of a general government, once in office, is both protected by the Constitution by making impeachment the only way to remove a president from office, and also the fact that to remove President Jefferson from office would be undermining the power of the people and act against the guidelines that are already explicitly set within the Constitution to do so. And having mentioned this constitutional principles would be an act against the Constitution to remove a sitting president from office through a judicial action. Now, I would like to state that in Powell v. McCormick, it actually states that the will of the people must not be restricted. And if we were to remove President Jefferson from office, we would be doing exactly this. Hence, this is why the only way to remove an president from office, as previously stated, is through the impeachment process. So if the Supreme Court were to remove President Jefferson, it would not only violate the separation of powers, the constitutional principles which hold this nation together, but would also go against the legal precedent established in INS v. Chadha, which specifically considers that, excuse me one second, which specifically considers that we cannot violate explicit constitutional standards, and the constitutional standards in this case would be the impeachment process. Additionally, I would like to also...
You have 2 minutes, I just wanted to let you know.
I would like to bring your attention to the historical underpinnings in this case. When Section 3 of the 14th Amendment was created, it was specifically to go against Confederates who actively participated in the overthrow of the government and insurrection to imminent lawless action. Therefore...
So, counsel, if I'm understanding you correctly, you're saying that this court has no jurisdiction whatsoever in something that should remain political in its very nature.
I'm stating that, in principle, the last and final word of if the president is able to be disqualified is with the Congress. And even if this court does decide
and
that...
And so disqualification is enforced by whom?
Disqualification, a decision can be made by the court. However, Congress, under Section 3 of the 14th Amendment, holds the final word. They can lift disqualification.
Even if the Constitution does not give us the power of reviewing the conditions, whether or not those conditions are met for disqualification, you are accepting that we have a say in it because Congress is at the end of Section 3 of the 14th Amendment suggested, but Congress.
I completely agree that there is a say. However, I need to reiterate that the final wording, regardless of if this court decides to disqualify the president, will lie with the Congress. And this has been seen in past precedent in which even Confederate officials have been actually, have had this disqualification lifted and they were able to still hold office. So I would like to conclude and implore this honorable court to see the discrepancies in the petitioner's arguments, which are based on faulty and dangerous assumptions and overbroad interpretations. The case before us puts the supremacy of the Constitution and the principles arising from it into question. My co-counsel and I have argued how the president both has the power to self-pardon and hold office regardless of his conviction under U.S. Code Title 18, Section 2385. Both of these are justified under our nation's constitution, and therefore convicting President Jefferson under either of these charges would be directly contradicting the supreme law of our land. Thank you.
Thank you, counsel. We have 4 minutes for rebuttal.
Thank you, Your Honorable Justices, for hearing the arguments that we have presented today. Before I go into the specific regarding how our side of the case demonstrates how the self-pardon is unconstitutional, as well as how Jefferson is ineligible under the 14th Amendment, I would like to first bring up how the respondent is trying to argue a case that is not at present here. They are trying to argue the conviction of Jefferson. That has already been established. We are not here to decide that. Therefore, any argument they have made on that grounds is ineligible. And furthermore, they were also self-contradictory. Their first co-counsel did say that he is in fact guilty. He didn't in fact respond to Your Honorable Justice question, saying that he is guilty. Yet his further co-counsel then came up to say that he did not incite, he came to his Twitter, therefore he did not do it, denying that very conviction. Therefore, their case was just frankly inconsistent at best. Next, I'd like to bring up the First Amendment, and them bringing up the First Amendment in terms of who's guilty, whatever. The First Amendment applies to freedom of speech. However, there's the idea of the proportionality of rights, which was addressed by Robert Alexie. In this case, we have hate provisions preventing hate crimes, and in this case, inciting insurrection. And in this case, the violence and the harm that came and violated people's freedom of security and freedom of life sort of goes above that of perhaps the freedom of speech, of which the Jefferson arguably went extended too far against, because in this case he was publicly motivating people to engage in such violence, and that are two different things than freedom of speech. And if, let's say, it wasn't his intention, he could have come out and said, this is not my intention, and therefore say that the actions of those who pursued it does not align with that of reality. However, he did not do that, which further deprecates how that was not his intention. Lastly, they try to bring up the idea that the court Congress will have the last word anyway. The fact that they said that demonstrates perhaps the overlooking of the separation of powers. This court cannot decide based on what they think Congress will say. This court is to make an unbiased and impartial ruling regardless. It is not our place to come and say what we think Congress will do, and therefore we will act accordingly. In terms of the ineligibility under the Fourth Amendment, it is not, Jefferson wasn't just speaking negatively about the situation, he was engaging in advocacy that ultimately was objectively tried to incite insurrection. And we would not be rewriting the Constitution by preventing him from holding office. We would be following it as it was defined, because he is an officer of the U.S. That has been established. He has swore to an oath to uphold the Constitution. That has been established. And he was convicted under 18 U.S. Criminal Code 2385, and thus he is therefore guilty and therefore cannot hold office. And now moving on to the idea of the constitutionality of the self-pardon. Or actually, no, first I'd like to touch on the fact that—
1 minute.
Okay, first I'd like to touch on the fact that the respondent tried to say how the petitioner did say the Constitution is above. I stand by the statement because the Constitution is still above. Section 3 of the 14th Amendment demonstrates how he is ineligible to hold office. The statute stands regardless, and even if we were to take the law above, our argument still stands. And then because nevertheless, he's already void of holding office. But to further emphasize the constitutionality of self-pardon, it is not unlimited. As we can see, especially in the conservatism of today's Supreme Court, where under Chief Justice Roberts, the overturning of Roe v. Wade, erasing 50 years of precedent to uphold the Constitution at its conservative era, and exactly as to what is embedded in the Constitution, demonstrates how we are following exactly what is defined by the Constitution, not what is in a wider scope, of which the respondent is trying to do. The Constitution is the supreme law of the land, which is why our argument aligns with it, and which is why not only is their case inconsistent and fragmented, but rather they are trying to stretch it to, one, to deny a conviction of which they first agreed to, and two, try and broaden and expand the Constitution to the point where not only is it not defined, but straying away from the intention of the Constitution entirely. And therefore, I thank Your Honorable Justice for hearing our opinion, and urge you to make the correct decision. Thank you.
Thank you, counsel. Ladies and gentlemen, we have concluded the competition. What's going to happen right now is me and my fellow judges are going to go to a conference room and reach a verdict on this case. We've already reached a verdict on the previous, and then we will assign the awards. So let's plan to be back here in about 25 minutes, so maybe 5:20. Please don't go very far. Thank you. Very quiet in here. Okay, well, I'm going to wait a little bit on the judges before I start reading out awards and such, but we're super impressed. It's probably to put it lightly, with the caliber of the performances and how well you guys did. So, congratulations. It was extremely difficult, and we changed our minds multiple times. So, yes. Before we read out the results, I'd just like our judges to introduce themselves, explain a little bit about them. We'll start with you.
Good evening. I'm Jaime Rodriguez. I'm a capital markets lawyer in Cuatro Casas, and I'm also a professor of civil law and private law at IE.
My name is Adrian Rubio, and I'm an administrative lawyer in Brussels, mostly dealing with EU regulation. And I teach administrative law and economic regulation here at IE.
Hello, hi, I'm Gonzalo Tella. I'm a corporate lawyer, but also I do a lot of pro bono. I've been litigating all my life for pro bono matters. That's it.
Hi, I'm Marina Higuera. I have just started my career. I have tried, I've been in the arbitration department, but I'm currently doing insurance, and I'm a legal advisor, so I was just there.
Good evening, I'm Margarita. I'm also doing a seat right now at the litigation department, and I'm a legal advisor. That's basically it.
Wonderful. Thank you. Now we'll read the verdicts of the court. Remember, the verdicts do not, that doesn't really, it's just, okay, yeah. Case 1, Paris Saclay versus Complutense. The court on the issue of the pardon says yes, a pardon can be made, self-pardon can be made in favor of the respondent. And in terms of disqualification, no, it cannot be disqualified in favor of the respondent. So unanimous decisions on both counts, and Complutense, if you were actually litigating this case, your defendant would be very happy with you. As for case 2, the pardon is allowed in favor of the respondent. The disqualification, however, the president would have been disqualified in favor of the petitioner, thus the pardon question not being that relevant. That was a 1-5 decision on both counts. Okay, now for the awards. So we have 2 Distinguished Advocate Awards to give out today for distinguished advocates. And our first one goes to Antoine. Where is he? Congratulations.
Do we say something or?
No, I don't.
And no, yeah, okay. We'll explain in a minute. And the second one goes to Lilia. Now we have 2 best written briefs, 1 per session. The first best written brief goes to Paris Saclay. And the second to Sciences Po. And now we have 2 Mitchell L. McLean Awards for Professionalism. The first going to Ignacio. And the second going to Kata. Is that you? That's I didn't know how to do your full name, so. Okay, should we do best oralist last or right now? Should we do the first and second place first and then the oralists? Yeah. No? I think first the oralists. First the oralists, okay. We have 2 best oralist awards. The first one going to Electra. Congratulations. And the second to Ignacio. And the moment we've all been waiting for. I'm going to read first place first and then second place, okay? The decisions were unanimous, as voted on by the panel. We took into account your briefs and your oral arguments and weighed them, and that's what made our decision. First place. Okay. The first place team is Sciences Po. And in a very close second place, IE Law School. With that being said, congratulations to everyone. This is my last competition. I will not be here for the following competitions. It's very sad, but it's good to know that I'm leaving in great hands and also on a good note. This was, I think, our best one yet, and I really, I'm very impressed and very happy to see how far it's come. And thank you so much to the teams, especially coming from outside of Spain and taking place. I hope you enjoyed it a little bit. So logistical stuff and really the thing that we're all waiting for, which is the cocktail. So a couple things. If you don't mind just gathering your stuff on the way out, just don't leave stuff everywhere. And then just remaining tranquil as we exit the building, as there are still clients within the building. Also no pictures upstairs or anything. We got a lot of pictures taken. Additionally, if any of you have any issues with being recorded, photographed, anything like that, please come see me before I leave, because we need to get that sorted because it was recorded and photographed. So we will make sure we deal with that as necessary. Cocktail. 9 p.m. for teams and judges and our ELSA France friends. Please, teams, if any of the people on the teams are not going, if you could please let me know, because we have exactly a number of spots, and there are some people that would like to come that we're on the wait list right now. So anyway, so congratulations, and I'm gonna adjourn the court. Adjourned.